Welcome to Vampire Divorce with Attorney Clarke Young.
Hey everyone, welcome back to an all-new episode of Vampire Divorce with Attorney Clarke Young. I'm your host, Mike Leon. Clarke here is a seasoned family law attorney, consultant, expert witness who's been helping parents and the court system navigate the realities of high-conflict custody cases. Today's episode, we're going to be talking about how moveaways and jurisdictional fights can be used as weapons and what it takes to protect your relationship with your child when the miles become leverage. Clarke, it's good to see you as always. This is always interesting for folks out there that are going through a divorce, thinking about maybe moving and stuff like that. So for the listener that's listening to this and maybe they haven't dealt with a move away case, what does the term actually mean with respect to the state of California and family law?
Thanks for having me, Mike. It's really a pleasure. Move away cases are their own little universe. And the fact patterns that come up are quite varied. So you might have people living under the same roof and then someone wants to move to another state. You might have one parent who decides they want to go back to whatever country they came from with the child, and it's an international issue. You can have situations where the parents are living apart and then one parent decides they want to move to another location again. And there's all kinds of wrinkles to all these things. So the governing statute is the Uniform Child Custody and Jurisdiction Act. And the word uniform is important because it means it's been adopted by almost every state. I think every state in the country, although every state has modified their version of the UCCJA for their own reasons, their own political reasons mostly. Those are the typical fact patterns, and that's kind of the lay of the land. You know, if you are going to hire an attorney to do that, you want to make sure that the attorney has litigated probably 5 or 6 move-away cases before you hire them to do one.
Yeah. And in your experience, why do borderline-driven custody disputes so often involve relocation attempts or even some type of jurisdictional maneuver?
Oh, well, that's an easy question to answer because the whole goal of the borderline is to subjugate another person to their will. And when they can't do that, then they have to destroy that person, right? That's the vampire that feeds on your life force. But when you abandon them from their perspective, they're saving themselves from their perspective, but from their perspective, you're abandoning them. Well, then you have to be punished. And that's when the vampire sucks out all your life force and you die. All right. That's really the vampire reference for this session. So the move away is a great thing to do because if you can take the child away, then you have effectively enslaved the other parent because the parent is going to want to maintain some relationship with the child. And now the child is being used has been weaponized to be the bait that the borderline will use to keep in a relationship with you. And it doesn't matter really to a borderline if they're getting positive attention from a person or negative attention. They just need attention of any kind, right? So the negative attention that they're getting in court and how they're destroying you financially and socially and familially and every other way, psychologically, emotionally, and through your child, that everything's open. Everything can be weaponized. There's nothing on earth that can't be weaponized by a borderline. So these move away cases are really just a tool, an instrument to subjugate you to their will.
Yeah. Let me ask you then, how does the distance in this regard, in terms of, the divorce and let's say one parent's in California, one in New York, how does that distance amplify the imbalance of power between the parents? Does it make it harder for the court to kind of see what's happening?
Well, what it does is that it enables, to use a psychological term, it enables the dysfunctional pathogenic parent to have all the power and control and all those things that borderlines need and want, right? Remember, it's always about control, manipulation, deceit, and then subjugation to their will. So when they do a move away, they've just empowered the pathogenic parent. And it's a whole other question and discussion. But what do you do as a normal range parent? I've coached people in the past, and I've done this where I've had borderlines move 2 or 3 times within 2 or 3 years, and every time they move, my client has moved next door. And after that happens 2 or 3 times, then you go in court and you say, you see what's going on here. The borderline is attempting to sever the parent-child relationship with the other parent. And then the court, after, again, always takes a year and a half or so, oh, I get what's going on here. And then they change the custody order and give primary custody and perhaps even sole legal custody to the normal range parent who has been targeted for the first year and a half of the litigation.
Yeah. So Clarke, in that example, the parent. Well, let's take a step back. Let's say the parent's threatening to move. What are some immediate steps that you would advise the other parent to take to preserve the jurisdiction and prevent any surprise filings in maybe another state or another county?
This comes up frequently, and the answer is you have to accelerate your game plan. So you have to be able to demonstrate earlier in the case than you might ordinarily want to or be able to, actually, that this move away is just an effort to alienate and sever the child. So you get that parent alienation and the interference with, and then eventual severing of the relationship with the normal range parent. And so again, when you're talking about, what can you do? It's everything I've talked about before. You've got to just keep documenting everything. I mean, you've got to keep diaries and logs and calendars and photographs and videos and text messages, and you're helping your client bring out into the open so the court can see the borderline's pathology. And at the same time, you're trying to make sure that your client, who has already been compromised psychologically because they're by the BPD, but they're already suffering PTSD, they're already suffering anxiety and depression a little bit. You have to do a lot of hand-holding to make sure that they're presenting as the normal range parent they are, despite the traumas they've endured at the hands of the vampire borderline. And at that point, if you document that well enough, you cross your fingers and hope to die that the court is a court that's a little bit open-minded and isn't going to just rule on appearances, or worse, rule on stereotypes. And we've talked about judges who just go into these situations and they're just issuing orders based upon societal stereotypes. That's a problem when that happens.
Yeah. Let's get a little bit more into the weeds on something I wanted to ask you to explain to the audience here, which is the UCCJA. The acronym stands for the Uniform Child Custody Jurisdiction and Enforcement Act. Can you explain how this fits into cases, why so many lawyers misunderstand it, and explain what it is, obviously?
Okay, so I'm going to walk this through from the practitioner's point of view. Assume I have a move away case and the UCCJA applies. There are somebody is either filed a motion to receive an order to allow the move away, or a party has filed a motion to prevent the move away. In either case, the issue is engaged. That we're going to be discussing this now, and at that point in time, it's probably going to trigger a child custody evaluation, and that child custody evaluation, if there's a psychological element to it, could take up to 6 months right there. So by asking for a child custody evaluation and a psych eval element to it, you are basically asking the court to do a very thorough evaluation of what's in the best interest of this child or these children. That's going to delay things a while and give you time to set up your chessboard. Secondly, the process in court. When you eventually get to the UCCJA hearing, there have been preliminary hearings probably uh, in the one court, and if there's another court involved out of state, you under UCJA, you have a right to ask the court in the other state to become involved with this decision. Now, this hypothetical assumes that the parties are already, the moveaways happen. But the one party wants to move again or something. So you're triggering the court's jurisdiction. Also, this happens in cases where one parent up and moves right away as part of the data separation. They just disappear with the kid and they go to another state. So now, then they file an action in that state, and then there's an issue: which state has jurisdiction over the entire bizarre, chaotic situation? So in that case, you're definitely going to have both courts involved. So the court has to decide jurisdiction under 4 elements. There's emergency jurisdiction, there's temporary jurisdiction, there's home state jurisdiction, there's other jurisdictions. But assuming that this was a move away from the home state, and I'm representing that home state litigant, I'm going to file motions in the home state asking for custody, visitation, and the whole 9 yards. The other party is going to say, well, I already got an order back here in this state saying that I could have custody of the kid, even though I haven't lived here, for the jurisdictionally required length of time. All right, so that's under usually 6 months. And if they have lived there over 6 months, then there's another level of issues. So now you're in court. Both parties have attorneys in both jurisdictions appearing in court on the same day as the hearing. You've asked the court to have this on the record. You've asked the court not to let the judges speak in private off the record. If a child is involved, that special proceedings and procedures have been set up to allow the child to testify under both states' rules, frankly, wherever the child is. And then you're going to have a hearing on which state should claim jurisdiction. If you are representing the home state, you'll probably win that. If you've waited too long to file that in the home state, and the other party has established residency in the other state, then it's going to be a crapshoot. I mean, the courts are going to go back and forth. How are they going to decide that? Well, the court's going to say, was the move away done to interfere with the relationship? We're right back to parent alienation. You're right back to borderline personality disorder. You're right back to all the other behaviors, Your Honor, that have occurred in this case before they even separated. You're going to be talking about, where are the witnesses located? Are they mostly in the home state? Is there family in the home state? Is there family in the new state? Is there a new person involved? Did this person leave and go to a new state because they have a new spouse, a new significant other? I mean, there's all these variables are going to have to be discussed. Was the kid in school? How old is the kid? What are the kid's contacts with both states? So all those kinds of issues are going to have to be litigated. And I'm going to make a footnote here. When these cases happen, all of this has to happen at the same time that you're dealing with the borderline issues and the other issues in the home state and preparing for all those issues in the home state. Because the more you can establish that the home state court has been dealing with this, the more likely it is the other state will defer to California, if not as the home state, then as the state that has the most contacts and connections to the family unit.
So, Clark, how do attorneys like yourself or other attorneys, how can they argue that the relocation issues um, are because of, a fresh start, as opposed to sounding like it's possessive or vindictive? How have you seen that play out?
Well, I live in the universe where I only litigate these borderline cases. So your case is more generic. It's just in general, what aren't there legitimate reasons for moving? Yeah, sure. Yeah. In a normal case where you have 2 normal range parents and they grow apart and they decide to divorce, separate, then you're back into a garden variety situation where the variables are weighed and they there can be very good reasons why you moved. You got a new job there. The company for whom you work transferred you there. This is the only place where you have a family support system where they can help you raise the child because he has, cousins and uncles and aunts and grandparents and all that. Different things like that. And that's a typical case. I don't do those cases. I do the cases where the move away is 100% of the time to sever the parent-child relationship. That's what it's about.
So as we wrap on this episode, Clarke, for the parent that's listening right now and they're facing this nightmare head on, what mindset or principles can help them endure the fight and kind of stay focused on their children?
Oh, that is a wonderful question. Look, the first thing I do with clients is I have a series of books that I recommend to them. I also have books that I tell them about that they should give to local counsel if I'm consulting with local counsel. If there's a psychologist involved, the child's therapist or couples therapist. And then there's actually books I give to healthcare professionals so they can help understand the process and get up to speed on what's expected of them. As far as my clients go, a lot of them really have been traumatized. There's a lot of distress, anguish, pain, suffering, sadness. They're trying to maintain a stiff upper lip and protect and shield the child from their own pain and their own issues and also from the borderline, which is impossible to shield them from that, pretty much. That's the judge's role, even though they won't accept that that's their role. They don't seem to get that that's part of this game we're playing. And so I need a good therapist. My client has to be in therapy. My client has to be doing a lot of reading. My client has to have a good support network, family members, friends, whatever. And they need my support and the support of my team to help negotiate this most traumatic chapter of their life. I mean, death is not as traumatic as a borderline divorce, and that's a fact. When you're going through a vampire divorce, there is nothing in your life that will ever, I don't even think combat, active military service with the PTSD is anywhere as sinister and pervasive as a borderline divorce. So that's the short answer to how you're going to have to help your client, because they're in a lot of pain and they need a lot of help.
Yeah. Clarke, thank you for the time and insights and breaking this all down as you best do. So appreciate the time.
Thanks for having me.
And thank you to everyone out there for listening to this installment of Vampire Divorce with Attorney Clarke Young. If you want to reach out to Clarke, connect with him, do me a favor, visit clarkeyoung.com right now. Don't forget to like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.